Okay. Hello to everyone. Happy Friday. Heather has a Norbar Board of Directors meeting this morning. So we're just going to do contract stuff and no tech stuff, at least from me. Unless one of you has a tech idea you want to share. Anybody have a pressing contract issue they have a question about that we can share with the group? Okay, then we'll jump into my topics. These are things that came up this week. One of our agents wrote an offer for a buyer on a property that had the seller had done 4 different reports: the past home inspection, roof, and a sewer, and had provided all those to our agent and had provided the forms to our agent provided them to the buyer. And so writing the offer, they wanted to acknowledge that they had received those reports from the seller and put down in the RPA under other terms that the buyer had received those reports and had identified them by name and date. And the listing agent pointed out to our agent, which was appropriate, that we don't really want to show those reports in the contract, the RPA, because when that goes to the lender is going to see that, and they're going to want copies of all the reports, and the reports may be problematic for the lender. The way we handle that is to either print the first page of each report and have the buyer client sign off on it and just say received and reviewed. You don't want to say they're accepted per se, but received and reviewed or received and read. And or you could possibly take the IO disclosure page, the disclosure IO page that's on the MLS, and print that out because it lists the reports, the one that lists all the reports that are in there, and just have them sign the same thing. Received and reviewed. So that's the proper way to handle the reports if you're writing the offer for the buyer. Any questions around that? Okay. We had a contract come up where the seller is a probate. And so we're using the probate agreement form here, the PAPA, PA-PA. And the probate purchase agreement, the default here under 1A is the property is part of a probate's decedent's estate. And that's the case here. The owner had died, so the property went into their estate, so it's part of the decedent's estate. If it were a conservatorship or a guardianship or a receivership, then those other boxes would be checked. But 1A is the default. And then if property is being sold as part of the decedent's estate, paragraph 3A applies unless 3B is checked. Okay, so then we'll drop down to 3 here about court confirmation. 3A discusses that the seller shall deliver within written notice to buyer at time of, and we would check acceptance or within the time of seller delivery. You have choice there. And if court confirmation is or not required. So the seller needs to advise the buyer if or not court confirmation is required. If court confirmation is not initially required, notice of the terms of sale to the beneficiary heirs is still necessary. If any beneficiary or their heirs object, then court confirmation shall be required. So some probates require court confirmation, some don't. Now, if we already know that this one's going to require court confirmation, we've been told by the listing agent that it will, then you would just check 3B. And then the sale is contingent upon the court confirmation, which is a court hearing, blah, 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 blah. So it could be overbid in the court hearing. So again, this is an addendum. This isn't a notice, this is an addendum. And then there's paragraph 4, all deals with when the court confirmation is required. This paragraph 6 was the one that came up this week, dispute resolution. The paragraphs for liquidated damages, mediation, and arbitration are deleted from the agreement. That's the RPA, it's referring to the RPA, due to the probate court having jurisdiction over the resolution of disputes and damages and awards. So in this case, our client, our buyer client, had initialed liquidated damages and arbitration. And that offer was sent off to the seller. And the question came back, well, is the seller going to have to counter those out? Because, you need agreement of the parties around those paragraphs in most cases. But in this case, because of this paragraph 6, dispute resolution, the paragraphs are automatically deleted. Then my view is you wouldn't need to counter out those initial paragraphs because they're already deleted by this agreement here. Okay, so that's what we got on the PAPA. We have a question on the listing agreement. Let's see, RLA. We are. And this had to do with exceptions to the listing agreement. So we're looking at the RLA, and it talks about the parties and the listing terms. Compensation, we deal with all of that. Inclusions and exclusions. And I don't recall if the RLA is being altered in this forms release or not, which is supposed to be done today, I think. But anyway, under additional terms here, we have a neighbor who may buy the property. And so our agent who's going to list the property agreed with the seller that if the neighbor buys the property, then we would accept a lesser fee than stated up here above in the compensation area. So let's say we had 3% up here. If the neighbor buys it, we're willing to accept 2%. If you're going to make such an agreement, talk it over with your manager or me. And this language here is, remember, we don't like creative writing, and we're going to have to be creative writing here. So run the language by your TC or by me and make sure we're okay with it. We can always run it by legal if need be. But in this case, if property is sold to Jack Flack during the term of this agreement, the commission to listing agent shall be 2% of the selling price. Now, we knew that the owner had offered the property to Jack Flack at a fixed price of, I don't know what it was, $500,000, say. And originally our agent was going to put in here 2% of $500,000. But you know, if the seller agreed to pay it, except $490 for it, or $499, $999, or something less than 500, there might be a question of whether we get paid or not. So we just changed that to the selling price. Remember, the language always needs to be clear. Everyone needs to understand what's being done and what's being handled. Okay, I'm going to stop sharing for a moment. Any questions on that issue? And if you're going to negotiate a reduced commission from what is typical in your office and policy, please review it with your manager and or me. Then we have we had a question on an RR. So let's go back here to forms and we'll look at the RR. And we wrote up an RR, and in this case, the buyer, we're representing the buyer, and the buyer requests, they did this one here, where the buyer requests that the repair, and then it listed some things that were electrical, sorry, I can't spell. Blah, 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 as spelled out in report items, spelled out in blank, report dated, blah, blah, blah. So, you know, again, in terms of clarity, we have to be real specific about, you know, what's being said here. That if someone read that and they didn't know anything about the transaction, that they would understand what and they looked at this report, they would understand what electrical items are going to be repaired. You might want to get as specific as identified as in paragraphs 1 and 2, you know, whatever the case might be. Just make sure you're clear. Now, so when we saw this, our agent representing the buyer said, this wasn't clear. And then the agent said, well, we met on the property with the seller, and the seller told us what they were going to do. So we understand what they're going to do. Well, that's all well and good, but it's not on paper, right? We got to get it down on paper. That's clear. So that's the issue here. If you're going to be asking for repairs to be done, be very specific about what you're asking the seller to do. And then, of course, if the seller, you know, wants to object to this or make a separate suggestion, we know they use the RRRR form. However, they can put in things down here. So here's the seller's response area of the RR form. So they either agree to all of buyer's request or partial agree. So in this case, the seller had written, something here, and again, they said, well, we're going to do this electrical, not that electrical. So again, it was a little bit unclear. And even though they had all gone over it in person at the property, the paperwork needs to be clear in case it doesn't get done and someone's going to object. And then there's other options under number 1 then, or 2, the seller responds to buyer's request for the attached RRR form. So, you could use either here. If the seller agrees here to a partial and it's okay by the buyer, then you would have the buyer accepts partial conditional agreement or does not accept and replaces request for repair number 1 with request for repair number 2. So that's kind of how that gets handled. The main thing I wanted to point out there was the clarity, that the language has to be really clear. Read it from a third party's point of view, that you're sitting there with the documents and you're trying to figure out what everybody means. Any questions on that? Okay. So we got that. We covered the PAPA. We covered the mediation arbitration. We have a property listing where there's a tenant occupying the property. Buyer wrote an offer that asked that the property be delivered vacant and said that the seller shall give the buyer 60 days notice upon acceptance of the offer. Because the tenant had been there over a year, so required 60 days notice instead of 30 days notice. This is not uncommon. However, the seller asked us, well, can I give them notice in the middle of the month? And, it's a month-to-month lease at this point. It had started on the 1st of the month. The tenant pays rents on the 1st, from the 1st to the end of the month. And here the transaction was agreed to on the 15th. Can the seller give notice to the buyer? I'm sorry, to the tenant on the 15th of the month that they need to be out in 60 days from then? Anybody want to venture a guess? Hopefully no one does, because that's outside our understanding and purview to know that answer. Our attorney said we can't answer that, particularly for this seller client. Remember, our attorney, broker risk management, works for us and gives us information and drafts things for us as agents, not for our clients. So they couldn't give the client advice about what notice was appropriate. And they pointed out that jurisdictions such as San Francisco or maybe Berkeley or other jurisdictions have different landlord tenant rules than maybe the state rules that are overarching, and the local rules would trump the state rules. So it's something really needs to be handled by a qualified California real estate attorney who specializes in tenant landlord relationships. So that's what we had to do, was direct the seller to find an attorney, and we recommended a couple to get clarity on that notice. We dealt with the RR. We had come up this week during the course of a transaction. The seller gave the buyer a new SPQ. And it changed one of the answers that the seller had made in the SPQ. So what are the buyer's options now? They had removed contingencies based on the TDS and SPQ and other information they had received, reports and so forth and so on. Now they get an altered SPQ. All right, so in terms of statutory effect, we did ask our attorney, okay, what's the effect of this? And Shannon wrote, there's no automatic right to cancel affiliated with the SPQ. The right of rescission is affiliated with the transfer disclosure statement. So as long as the TDS was not altered, no right of rescission is triggered. So they suggest, our attorney suggested that we immediately deliver the altered SPQ to the buyer. And if the buyer finds the issue to be material, the buyer can ask for cancellation of credit. If the seller refuses, then the buyer needs to talk to the QRCA, the Qualified California Real Estate Attorney, about the rights. So that was kind of the procedure for handling the altered SPQ. Of course, if you get an altered TDS, it does reinstate the 3-day right of rescission that travels with the TDS. Any questions on that one? I'm covering some exciting topics today. Let's see. We have some tenants or some agents who are representing a nonprofit to which they are affiliated, and they want to make a contribution from their commissions earned in the transaction to the nonprofit, and that's all very fine and good. However, the credit needs to be adjusted by the amount of the company participation in the commission, and or approved by us that we're going to give our share of the commission as well as their share. So whether it's a nonprofit or a credit to the seller, whatever credit the agent wants to give to whoever they want to give it, needs to be done after we've calculated and approved the company dollar that's going to be received from the commission, and then the net commission the agent's free to do with what they want. So if you're ever asked to give a credit or want to give a credit as part of your earned commissions in the transaction, just clear it with your manager or me before you do that. Any questions on that?
Hey, Gary, I actually do have a question about the TDS and SPQ. Sorry, I got a call, so my computer kind of seized up on the Zoom as well. Why would the TDS allow a 3-day right to rescission, but the SPQ wouldn't?
Well, the TDS is a statutory document that is state law.
Okay.
And, CAR proposed that document because, of course, Coldwell Banker always is the cause of these things. But, but way back when there was that case where the seller failed to disclose a slide on the property out in somewhere, and the buyer, the property slid again after the buyer bought it, and it became known that the seller knew about it and they didn't disclose it. So and it was a big lawsuit, and Coldwell Banker represented both sides, and they got called into the lawsuit and had to settle. So as our lobbying organization, Coldwell Banker, CAR introduced legislation, and it was approved and that's the TDS. Same thing with agency. I mean, agency disclosure is a statutory document that was introduced so everybody knows who the agents are and what their duties are, because there was a lawsuit around that way back when. So that legislation about the TDS includes the 3-day right of rescission. I guess somebody thought that, you know, if you can, you have, what is it on a car, the lemon law, you can have a lemon law on properties too, for at least for 3 days, if you get a TDS and there's things in there that you don't approve of. So that's the 3 days right of rescission on the TDS. The SBQ is not a statutory document. It's just a document that CAR and created to embellish more about the property. It's not required in transactions. The TDS is required, except when there's an exemption. But the SBQ is optional, but it has become standard of practice for the SBQ to be completed and delivered. So, you know, remember standard of practice when you go to court and they say, well, what do you do in a transaction? You say, well, we get the seller to sign an SBQ. That's our standard of practice. And that would be the way we do things. But it's not, that's why it doesn't tie back to the right of rescission.
Understood. Thank you.
Okay, good question. All right. We had this, let's see. Well, I'm not sure exactly what you're seeing. Are you seeing the sharpen your skills or the counting days thing?
Legal holidays.
Yeah, okay, great.
Yeah, there we go.
This was last week's practice tip. I hope you looked at it. I mean, we go over this every once in a while. And it's like, how do you count the days when in a transaction? This admits that counting days is a source of confusion, and the answer depends in part on which purchase agreement you're using. We really only use the CAR RBA. We don't use the PRDS or the San Francisco, but you could be in a transaction in those places and there's a different contract used. So the general rule is that when a contract is accepted, which is the date that the last party signed an unchanged offer or counter offer, and the contract is delivered to the other party or the designated agent. That's day 0. And remember, you know, this has to be delivered. So the seller could sign it and say today is the 23rd, June 23rd, but it doesn't get sent over, and that's the date on the document, but it doesn't get sent over to the cooperating agent until the 24th. That's delivery. So that makes 24th day 0. And then the next day is day 1. So if you have 17 days or 10 days or whatever number of days you're counting, the date of delivery of the final unaltered document is day 0. And then you start counting the next day is day 1. The time of day that the contract accepted or the notice of delivery is not relevant between timeframes. They're not calculated based on hours, but only on full 24-hour days. So if it's accepted at 5 p.m. on a day, you just say, okay, that whole day is day 0. You don't say, well, day 0 starts at 5 p.m. the next day. So, you know, that whole day becomes day 0. And then there's, you know, legal holidays, definitions, and things like that. So this is a very useful tip. I'll include it again in this week's, when I send out the recording. So if you need to refer to it again, it'll be available to you. Okay. And then stop share on that. Any questions on counting days? Discuss it with your TC if you have any questions. I believe our TCs do a timeline for us. Is that right, Rob? Yeah, they do. So, and your thoughts should correspond. You get a timeline from our TC, and it doesn't correspond to what you're thinking. Make sure you discuss it with your TC, and if need be, the TC will check with us, and we'll get it, everybody on the same page. I've got just two other things. I was attending a webinar the other day, and it was on improving your business and improving your education and continuing to grow your knowledge in the business. And they talked about these 4 designations, the core 4, as they call them. Can you see that, Rob? Well,
Yes, we can.
okay, all right. So the core 4, and these are NAR designations, are ABR, which is accredited buyer representative, the SRS, which is a seller representative specialist, the RENE, the Renee, the real estate negotiation expert, and the PSA, the pricing strategy advisor. There's other designations that I know some of you have, or other of our agents have. One is the SRES, the senior real estate specialist. And that's really nice to have if you're working with subdivisions with seniors and things like that. That's a good one to have on your card. And there's of course, there's the CRS, Certified Real Estate Specialist, and the CRB, Certified Real Estate Broker, and other ones. I think there's a green one now. You can get a green realtor or something like that. Anyway, these are what this party who was doing this webinar thought were the core 4, but any designation that is of interest to you, check it out on the NAR website. And then when you get these, you can use this logo on your business card and your correspondence and in your marketing to promote your skills. So that's those are always good to get. Any questions there? Okay then. And finally, let's see, 2 other things. They're related. We're going to have the CARs doing their forms release, I think sometime today. So I'm sure we'll get an email from CAR saying the forms have been updated. And then if you open up a new transaction tomorrow, it's going to load up the newest forms. And I'm sure the CAR package, when they send them out, will have a reference to explanation documents. Sometimes they have already their lawyers doing an online presentation about the changes to the forms. I think there's like 60 changes, some new forms, but in total like 60 changes to our standard forms. So Norbar is doing a class on the legal update. If you remember Norbar, that's on June 27th. You go on the Norbar website and check for the registration. And then broker risk management, our risk management team is doing their forms release up webinar on Monday, July 10th, 9:30 to 11. So there are 2 new contingency removal forms, and then all these revised forms that they'll be covering. So this will be probably the most extensive webinar that we can do on this. And I plan to attend both NORBARs and this one. As with the other BRM broker risk management webinars, this requires advanced registration to get the link to the Zoom. So I will send that out when I send out the recording here and my update on Monday. So be sure to register if you can attend, and we encourage you to attend that webinar on July 10th and any other ones that are available to us before that. Probably next week, we'll have more to talk about the forms that were released this week. Okay. That's all I have. And for you, those of you who got here after I had announced that Heather is in a board meeting this morning, so we won't have any tech side update, but that's our contract update for the week. Any questions or comments?
I believe Heather is planning on doing another Moxie training course.
Great.
I'm just looking through our joint calendar right now. I truthfully don't know when it is, but I do know it's sometime in the next few weeks.
Yeah, and we have a recording of the one she just did on Tuesday in Sonoma. And I know that some of the folks in Sonoma were very pleased to get into Moxie. I think they were doing Engage and get all their contacts loaded onto Moxie from their other. I think one person had 1,300 contacts on their phone. She was able to load them all into Moxie, and now she has to sort them so they're useful. But at least we got them over to the Moxie. Curtis points out he's been helping some of our agents with MLS issues and practices, and he's if you have an MLS question that's not covered in their tutorials, or you want to reach out to Curtis, he's happy to work with you on MLS issues, and we'll talk about that. Curtis doing one training here on the Fridays. Thank you for offering. Okay, everybody, that's all I've got, and everybody have a great weekend. Take care.
Thank you.
You're welcome. Bye.
Thanks, Gary.